All right, it is 10 a.m. and um, we are here for the California Board of Psychology Legislative and Regulatory Affairs Committee meeting. I will have Miss Whitney call the roll.
Morning, Kasuga,
Here.
Cervantes,
Here.
Rogers.
Here.
Thank you. Quorum's established.
All right. For now, I will have Mr. Polk talk about CPD credits.
Thank you and good morning. Attending today's committee meeting provides you with CPD credit under category number 1, attendance at a California Board of Psychology meeting. The hours that will be credited for attending today's meeting will also count towards law and ethics. For your CPD records, please notate today's date as April 11th, 2025, and note that we are here for the Legislative and Regulatory Affairs Committee meeting. At the end of today's meeting, I will announce how many hours will be credited for attending the full meeting. For attendees who joined by phone by calling the U.S. toll number and use the access code, please send an email to the following email address: bopce@dca.ca.gov. Again, the email address is bopce@dca.ca.gov. In the email, please provide your name, license number, and the phone number of the phone you called in from. Attendees who signed in using a computer or mobile device from the WebEx link, your attendance is automatically documented and no further information is necessary as your name and email address is recorded upon joining the meeting. Again, at the end of the meeting today, I will announce how many hours will be credited for attending today's full meeting. Thank you.
Thank you so much, Mr. Polk. Now we move on to agenda item number 2, which is the chairperson's welcome and opening remarks. I am delighted to and deeply honored to chair the Legislative and Regulatory Affairs Committee with my esteemed committee members, Dr. Cervantes, and our new member, Dr. Rogers. Do you want to say a few words, Dr. Rogers?
Good morning, Dr. Kasuga, and good morning, everyone. I am delighted to be on the committee. I am sure there's lots that I have to learn, so I'll be more in an observing capacity today, but I'm really, really thrilled to be working with the two of you and the rest of the board staff. So thanks so much for having me, and it's a delight to be here.
Thank you so much, Dr. Rogers. I also wanted to acknowledge that Dr. Cervantes served as the chair for this committee for several years. So I just wanted to acknowledge your service, and hopefully I can follow on your footsteps in the this upcoming year. And Dr. Rogers, maybe next time we can put into our agenda a mindfulness activity to start our committee meeting.
I stand ready to serve in any capacity.
Thank you so much. And a few housekeeping. We are on the agenda. It's from 10 a.m. to 3 p.m. or until completion of business. We will have a 5-minute break, about an hour or so. And if we hit the 12:30 p.m. mark, we are required to have a lunch break. So we will have at that point a 45-minute lunch break. So we'll play it by ear in terms of how long the meeting will be. And let's jump right into agenda item number 3, which is public comments for items not on the agenda. The board may not discuss or take action on any matter raised during this public comment section, except to decide whether to place the matter on the agenda of a future meeting, on a future committee meeting. Before I invite speakers to come forward for public comment, I would ask individuals making comments to not discuss the specifics, including names, as to pending complaints, pending licensing applications, or pending disciplinary action that may come before the board for a decision. This refers to current and pending complaints and possible future complaints. Such decisions are considered ex parte communications, as they would provide information to the members that is outside of the record in violation of the Administrative Procedure Act. While there may be a desire to engage in further discussion with comments presented during this time, the board may not discuss or take action on any matter raised during this time. Although this may give the impression that we are not being responsive, these procedures are critical to ensure the compliance with the Open Meetings Act and to avoid compromising the speaker's goals or the board's mission. In addition, if there is a speaker before you who expresses thoughts that are extremely similar to yours, please feel free to verbally agree with previous speakers instead of repeating the exact same comments. Each speaker will have 3 minutes. Mr. Moderator, can you open the public comments section?
We are open for public comment on agenda item 3, public comments for items not on the agenda. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand. And for our mobile device users, you have 3 different screens and only one of them has a hand button, so you may need to hit the ellipses button. That's the ... in order to find your hand. We're going to take a few seconds now to see if we have a request for public comment for items not on the agenda. As stated previously, you'll be given 3 minutes to speak, and I'll give you a 30-second warning before your time expires. All right, looks like our first comment comes from Cynthia Webster. Hold on just a second. We're sending... All right. I see lots of hands coming and going. Please leave those hands up if you wish to be called upon. We're going to give it just a few more seconds to see if people actually want to make a public comment for items not on the agenda. Looks like our first comment's coming from Trisha Wallace. Hold on just a moment. We're sending you a request to unmute your microphone. All right, Trisha, we saw you mute and then unmute. We're going to give you another opportunity here.
Morning, can you hear me?
Yes, go ahead, please.
Wonderful. Apologies, that was my problem. It was my settings. My name is Dr. Trisha Wallace. I'm a licensed psychologist in California, and I am a provider of gender affirming care with a specialization, in gender affirming care. I would like the regulatory and legislative committee to please consider strongly supporting Assembly Bill 82. It extends protections for licensees like me in our it proposes to do that in our government, in our state, extending protections because, as we know, in this current political environment, providing gender affirming care at this time is a scary business, and providers and patients are being targeted by people who are not supportive of that care. And so I strongly humbly ask the committee to consider putting forward to the board to take a position of support of AB 82, which, if approved and signed into law as it is right now, it would extend protections so that licensed psychologists in the state of California who are providers of gender affirming care can take part of a Secretary of State program called Safe at Home, where you can block your home address from being able to available to folks. And it can extend protections if there are people that are targeting you who, as a gender affirming care provider, both including mental health care, and if there are threats on the internet that are done in relation to your work as a gender affirming care provider. So I strongly support that, and I'm happy to take any questions offline. I'm happy to provide my contact information if people would like additional information as well. Thank you so much for listening, and I appreciate the support.
Thank you, Dr. Wallace.
Next, we're going to hear from Marilyn Imuz. Hold on just a moment, please. We're sending you a request to unmute your microphone.
Can you hear me?
Yes, go ahead, please.
Yes. I'm really pleased to be with you today. I represent California Department of Corrections and Rehabilitation and am not at this point allowed to take a stand on some of these issues that relate to statutes and legislative process. But I fully support the board's work in this. And at a later time, I would like to be able to possibly make a contribution that is related to the CDCR. However, at this time, I'm basically mostly an observer. I think this is wonderful, the work you do. And I am going to be retiring at mid-October after having worked with the board for, I think now 12 or 13 years. It'll be a sad day for me, but I really appreciate all of the work that the board does and the collaborative work that we've done over the years, the ability to be able to bring also our views to the table. So thank you from me also personally.
Thank you, Dr. Imuz.
And that was our last request for public comment.
All right. Mr. Moderator, you can close the public comment. Okay, moving on to agenda item number 4, discussion and possible approval of the committee meeting minutes from June 14, 2024. Do I hear a motion?
So moved.
I second.
It's been moved by Dr. Cervantes and seconded by Dr. Rogers. Okay, so I do have a non-substantive grammatical correction on line item 142. And it's just, I believe it's though instead of thought on the first word on that line. Even though they may not directly impact the provision of mental health services per se. Any other board comments on the minutes? Seeing none, let's open it up to public comments.
We are open for public comment on agenda item 4. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand. And for our mobile device users, don't forget about the ... button in order to find your hand. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue?
Yes, thank you. Ms. Whitney, can you call the roll, please?
Kasuga,
Aye.
Cervantes, Rogers.
Aye.
Thank you, motion passes.
All right, we're moving on to agenda item number 5, legislation from the 2025 legislative session, review and possible action. So we'll start with 5A, legislative proposals, 2025 Sunset Review Report. I welcome Mr. Burke.
Good morning, Dr. Kasuga, Chair of the committee, and committee members. This is just a verbal update on where we are in the sunset process. We had our hearing on the 24th of March. It went well. The panelists who went up were myself, Sandra Monterrubio, the Enforcement Program Manager, and of course, Dr. Tate, the President of the Board. We presented what we had done and what our concerns were, and then we were asked some questions. Not too many. The focus was Assemblymember Corey Jackson asked several questions and voiced opposition to the psychotherapist patient privilege exemption that we're requesting. Assemblymember Berman asked about workforce development and helping psychological associates into the profession, and Senator Ashby asked about the temporary practice provision, the 30-day temporary practice provision, which is in psychology law, and specifically in light of the somewhat more rigorous reporting requirements that the Board of Behavioral Sciences has. In fact, just before the hearing itself, we were sent a detailed background question, series of questions from the committee staff. Staff are currently drafting responses, which will be considered and approved by the full board at the meeting next Thursday, which is a public board meeting. It will be held via WebEx, where the board will review and consider those responses. We will then get them sent off to the Assembly and Senate committees, and then at some point this summer, our sunset bill will be introduced. So that's where we are in the process. Are there any questions?
Any questions from the committee members? Okay, Dr. Cervantes.
Thank you for the update, Mr. Burke. I haven't seen a draft of the questions come through. Will we have an opportunity to review those before the 17th?
Absolutely, yes. They're actually going to be uploaded to the box today and sent out to all board members, and it will also be shared for the public as well. Board members, even those not in attendance on Thursday, because obviously it was a quick turnaround special meeting. And obviously the spring break is here, so some people had already had plans. And board members, please, will be able to make comments, updates, edits, and then they will be discussed in the full board meeting. One item will be a hand carry. It actually relates to the 30-day temporary practice provision that I already mentioned. That's because that will involve it involves the actual drafting of proposed legal language. So that's obviously got a slightly higher level of review. So yeah, that's where we are. But you will be they will be being sent out to you today. Thank you.
Thank you. Any questions, Dr. Rogers?
No questions. Thank you.
All right. Do we open it up for public comment?
All right, we are open for public comment on agenda item 5. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take a few seconds now to see if we have a request for public comment.
Just for clarification, it's only for 5A.
Seeing no request, do you wish to continue with the agenda?
Yes, thank you, Mr. Moderator. All right, thank you, Mr. Burke. We'll move on to agenda item 5B, review of bills for review and consideration for action position recommendation to the board. I welcome Ms. Mancia.
Thank you, Dr. Kasuga. So the first bill, SB 470, the proposed bill was introduced on February 19th by Assemblymember John Laird. The bill amends the Bagley-Keene Open Meeting Act by permanently extending provisions for the state body teleconferencing that were originally set to expire January 1st, 2026. The bill maintains the rules that allow state bodies and advisory boards to conduct meetings via teleconference with several key requirements: that the meetings are visible and audible to the public, remote access is provided, public comments are allowed, agendas are posted online and at least 10 days in advance, and at least one member is physically present at teleconference location. The bill also allows members to participate remotely under certain conditions, such as accommodating physical or mental disabilities, and mandates roll call votes with public reporting of actions. Members are required to appear on camera during open meetings. By removing the repeal date, the bill makes teleconferencing a permanent aspect of California's open meeting laws. On February 26, 2025, SB 470 was referred to the Senate Committee on Governmental Organizations and the Senate Committee on Judiciary. On March 12, 2025, SB 470 was set for hearing for March 25th, and on March 25th, SB 470 was re-referred to the Senate Committee on Governmental Organizations and Senate Committee on Judiciary. And the latest update was the SB 470 was set for hearing on April 8th. Board staff recommends that the board takes a support position for SB 470.
Thank you, Ms. Mancia. Do I hear a motion? Oh, do you have a question, Dr. Cervantes?
Yes, I have a comment before we consider a motion. And the laws on the public meetings have been evolving since the pandemic. And I guess I'm concerned with the requirement that when we have board meetings, if we're having them remotely like we are next week, that all addresses are required to be noticed. And the reason for my concern is that at a location, it may only be the board member there with a computer having participating in the meeting. And there's a number of issues of concern with that requirement. First is safety of the board member. Whether it's a place of business or a home where they're taking a remote board meeting. Second is the logistics of actually having members of the public participate in a meeting that's remote in that way. And so I appreciate the recommendation to support, but I think there are some logistical considerations that we should elevate at this opportunity rather than just send a blanket support. That's where my thoughts are on this.
Thank you, Dr. Cervantes. And I think that the safety of the board members is definitely should be accounted for. So my question for board staff is, have you reached out to other boards, and are there other boards that have similar concerns about safety and about this particular bill?
No, I personally have not reached out to other boards, but in a round table, when this bill was brought up, safety was not a concern that was brought up.
And this is Anthony. Just from a legal perspective, Member Cervantes, you're certainly highlighting some policy issues that are certainly in play here. What I can tell you from a legal and historical perspective is prior to COVID, there wasn't some of the changes that are in this bill that we've had since COVID did not exist before COVID. Before COVID, all of the addresses had to be displayed. Then we had COVID where we could all participate remotely. And then post-COVID, there was kind of this middle ground where some of the addresses, as long as certain circumstances or conditions were present, you didn't have to list all of the addresses, but you had to list most of them. This is putting in as a permanent what was a temporary fix, that sort of quote middle ground. So prior to COVID, you had this teleconference option where you could have multiple addresses listed and they were all joined by some electronic medium. That is still allowed. So I would probably suggest that I think security is a concern no matter which version. I think that's something we always need to be aware of. But from a legal historical perspective, the disclosure of addresses, if you look at the total number of required disclosure of addresses for meeting locations now versus pre-COVID, we're actually disclosing fewer addresses. Obviously, there are new conditions that are in the law that sort of require us to, satisfy first, but overall, compared to pre-COVID, we're actually disclosing fewer addresses.
I just have some real concerns about that. I know we're in we have different conditions, like you said, and it just presents different issues. For example, there's also costs, and like when we publicize a meeting location, for example, the public would have an expectation that they could participate in the meeting at that location, but it is probably an unequal participation, an unequal experience, right? Maybe at one location there's seating. If at another location, maybe the seating is, for example, a couch, right? You're not like in an office, right? Like there's just different conditions that may make the participation that may not meet the expectations of the public to participate. And so I guess I just want to air these concerns so that they're elevated to the authors, because I'm sure we're not the only board that experiences these things, so that they could develop language that's more inclusive and realistic of the experience. Because if I'm on a laptop at a location, for example, I'll be at a DCA office next week taking the meeting, and I'll have a laptop. If a member of the public comes and wants to participate in the meeting, it may be difficult if I just have one laptop there, right? And I won't necessarily have an IT crew there to help me create a condition for anyone that walks in to equally participate. So I guess I'm not opposed to supporting this, but I would like some comment about these issues so that the policies can better accommodate the conditions right now. There is cost savings to the state by not having by having meetings in like on WebEx where people can participate from anywhere in the state and we don't have to travel to go to meetings. There's savings in that and more opportunities to participate. And I love that. I absolutely welcome that. But I also don't want to create a false something that's not actually there. We still have some things to work out. How might we get to that? Could we maybe support if it's amended to address these issues, or if we support and indicate that we still have concerns about these issues? Do you have a recommendation on that, Mr. Payne?
So one thought I have is the committee could certainly, one option, of course, is just to have support, and the meeting today is certainly a matter of public record that the legislature could choose to review and include all committee members' comments in crafting potential amendments. I suppose another option is a support if amended. I think the caution with that is then I think it sort of suggests maybe we need to come up with what the amendment or the specific language would be that would get support and what that would look like. So I suppose that's another option as well.
Or could we just monitor this and not take a position right now until we have some more discussion? I'm sure I raised these issues that I have, but there may be other things I'm not thinking about. And staff might have some issues that they deal with on logistics that might need to. I just think we can get to better policy on this. Is it okay if we just not take a position right now?
I'll let thank you, Dr. Cervantes. I'll let Dr. Rogers. I think she raised her hand earlier. I don't know if it's to answer yours or, I'll let you talk, Dr. Rogers.
Oh, actually, thank you, Dr. Kasuga. It's actually something that Mr. Payne just addressed when Dr. Cervantes was raising her concerns about safety. I wasn't sure if it was possible to support if amended, but I understand that if we do go that direction, we would have to come up with some language that might be acceptable. So that's my only comment. Thank you.
All right. So just talk about my personal experience with the remote meetings. I'm coming from the Bay Area and usually would use the state offices. So safety is something that isn't much of a concern because the buildings usually have the state buildings usually have the whole metal detector, thing for entry. So I appreciate Dr. Cervantes bringing up that there are different situations and conditions that different board members have when they're participating remotely. So I appreciate that. And I also appreciate the mention of the technical issues that sometimes happens when it comes to these meetings where we're in there's like there's difficulties with Wi-Fi, or like what Dr. Cervantes said, that there could be not enough visuals. We don't have kind of like a paper copy of our meeting agenda for someone to follow, for instance, or copies of the materials handy for someone that wasn't able to access it through the Dropbox or whatever is available to the public. So that's a consideration. So like Mr. Payne, so it's my understanding that we could also go to Sacramento, or if it's like if it's a remote meeting, we're asked to not go to Sacramento, or like they won't pay for our travel if we do decide that that is the safest and kind of like best option for us, if we're not able to feel safe doing it at like remotely.
So I think under this bill, I think there's still a lot of options available for meetings. One option is using public spaces. Those tend to have more seating available. Another option is to coordinate with locations that have an increased security presence. I mean, that's another option. The law doesn't require, the law just requires that we have a meeting space that's noticed to the public. It should be ADA accessible, and the people should be able to participate. It isn't heavily prescriptive beyond that. So it's possible to have those locations vary, and that is sometimes a positive aspect, but as Member Cervantes just mentioned, there's also some inherent concerns associated with that level of flexibility, but the flexibility is still there. So I think I would recommend we leave it up to individual board members or the board to sort of weigh those policy concerns about which is more important when we sort of scope out locations for meeting locations. It may make sense in a particular circumstance for people to meet in one location. It may not. There may be a proximate location near a particular board member that satisfies all of the requirements, and the board member feels comfortable with that location. It runs the gamut a bit as to comfort levels and what the public address is for that meeting. And as I mentioned, one option under this version is to have a majority in one location, and the additional members can appear remotely without disclosing the location. So there are some additional avenues that as I mentioned, overall, compared to pre-COVID, we're at probably disclosing fewer locations than we used to.
So can you clarify that again, the last one? So we can have designated like addresses that we're gonna disclose, and that's where the public can join, and then we can have other addresses that like we don't have to necessarily disclose.
So for example, there's an option that if a majority of the board were to meet in Sacramento, in one location in Sacramento, the additional members could appear online without disclosing their address. That's allowed under this, that's actually currently the law, and this bill essentially just removes the sunset date associated with it. So that would just continue to what we already have as an option. So that has worked well with boards when you have certain members with particularized health conditions and may require them to appear remotely. And so what boards have done is they have their majority in one location, and those members, in addition to that, are able to appear over some media platform, and their address isn't disclosed on the agenda. So that is an option under this bill. So I do think that this bill does allow, compared to pre-COVID at least, additional flexibility for how meetings are conducted and where they're conducted, and the level of specificity and disclosure of locations for those meetings.
Thank you, Mr. Payne. I do appreciate the flexibility of the kind of like whatever you're calling the middle ground in terms of like the remote ability for board meetings. As you can see right now, like this committee meeting pre-COVID doesn't really have a big attendance and participation, but because of this WebEx, we have a lot of attendees that are able to participate. So that's another thing too. And I appreciate the ability of a lot more people to participate in the meetings. So like in terms of recommendations, I guess like our options are to and Mr. Payne, please feel free to kind of like provide me with other options in terms of the ones that have been raised today. So there is like the staff is recommending support. There is like and then we can opt to support with like voicing out some of our comments. We can do a support if amended, if we have specific amendments that we want to see in the language of the bill, or we could watch it. Are those the main options that, like, given the discussion?
Yes, yeah, because you're right, Chair. Obviously, oppose is always an option as well, but I know hasn't been the tenor of the discussion thus far, but yes.
Is there a motion from the committee?
I move that we watch this bill and maybe consider a position at our next meeting.
Do you have a second? So like if we don't have a second, is there other like motions that people want to put forth? Or well, how do we proceed?
Yeah, I've been listening to the discussion back and forth, and I appreciate Dr. Cervantes' comments about the safety concerns. I also really appreciate, excuse me, Mr. Payne's discussion of the way in which the bill has been written to date, where most members can gather in one location, for example, in Sacramento, and if other board members need to meet remotely and not have their address listed, I support that. I feel like that still allows board members to meet remotely without potentially putting themselves in harm's way. So I actually am comfortable with with supporting this as written.
I would second that, Dr. Rogers. And I guess like right now, what we can do is open it up to public comments and then have the public provider input with regards our discussion. Mr. Moderator, can you please open the public comments?
We are once again open for public comment, this time on 5B1. That's Senate Bill 470. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. And it looks like our first request is coming from Christy Van Eiken. Hold on just a moment, please. We're sending you a request to unmute your microphone. Are you with us?
Yes, can you hear me?
Yes, go ahead, please.
Great. My name is Christy Van Eiken. I'm with the DCA Legislative Affairs Office. I just wanted to very quickly note that this bill was actually amended yesterday. So rather than permanently removing the sunset dates that are currently set at January 1st, 2026, it's now extended that sunset date to January 1st, 2030. So it's no longer a permanent removal of those sunset dates. It's simply extending the existing sunset date.
Thank you.
And that appears to be our only request for comment at the moment.
All right, Mr. Moderator, you can close the public comment section. Ms. Whitney, can we have oh, sorry, Dr. Rogers.
I'm so sorry before we take a vote. I just have a question as someone who was appointed just before the pandemic. So I was appointed in November of 2019, and my very first board meeting was in February of 2020, just before we got the emergency stay-at-home order. So I was just curious, prior to the pandemic, how committee meetings were conducted. Were committee meetings held via WebEx in this way, or were those also in person?
As far as I can remember, I mean, it's been a while. So as far as I remember, we would go, the committee members would go to Sacramento, and we sometimes had like a WebEx, but we were all in one location. I believe that's how it was, but I guess board staff would know more.
So I can talk a little bit about this. Prior to COVID, we could all meet in one location, say for a committee meeting. It was still available, although I think logistically it was probably a little bit more difficult, but the teleconference option was still a possibility. So theoretically, for this committee, we could have 3 different locations and everyone is connected through an electronic medium. And those mediums have changed over time. And the options for those mediums have changed over time. But the option as a teleconference to list 3 different physical locations, say for this committee meeting, for example, was a possibility. So that is, Dr. Rogers, to your point, that is a change where now under this bill, and what we've been doing sort of post-COVID is an advisory group, such as a committee meeting, can appear entirely remotely without having to list 3 different address locations or even 1. Now, we do always have to keep 1 location for staff, but as it relates to board member locations, that they could all appear remotely for that.
Okay, thank you, Mr. Payne. That's really helpful. I appreciate it.
Any other board comments or discussions? Yes, Dr. Cervantes.
Um, I still think we could get to better policy on this. As a person who does not reside in the Sacramento area and has sometimes struggled to find a suitable location to hold a meeting so that the public can participate, and have struggled to have to find adequate space. And I really strive to create opportunities, you know, if someone does come in, that they're able to participate. There's because the conditions are different, it's and the amendment to create a now or to extend this and have another sunset date in 2030 to me indicates that we're still feeling things out here. I think there's an opportunity here to just to participate more in the policy making process. I'm not opposed to the bill. I just want to participate more so that we have a, a more realistic expectation for the public. We have 224 attendees at this meeting. Pre-COVID, when we would have these meetings in person, I was happy to see one person in the audience. There's a lot of conditions that have changed, including our own continuing education process. But it's good to have participation, and I just think that we can get to better. So I hope we can have staff staff and the person who did public comment on behalf of DCA continue to participate in those discussions to create a better environment for everyone participating, including the board members, because if it becomes logistically difficult for some board members to participate, then we're also creating unequal opportunity for members of the public to participate in our regulatory process. And so I just want to enthusiastically encourage more discussion so that we get to better practices and a policy on these meetings that balance the public and the board needs. And the board, I don't just mean the members, but also the staff and logistics and costs. That's all I want to say on that. Thank you.
I appreciate that, and that's one of the things that I appreciate about this committee has always been very thoughtful and diverse in ideas. So I really appreciate your contribution, and I think that this is something that we should continue to talk about, especially with the larger board. The larger board meetings. That way, all the board members would be able to provide their own, thoughts and experience. For me personally, I think that the benefits of the flexibility outweighs some of the reservations that I have. I think that the flexibility at least provides for more security if that's needed. But I also appreciate what Mr. Payne said about if we vote to recommend to the full board a support position, that some of the concerns will not just go away. It will be brought up, albeit not like as an amendment to the legislation, but more of as like concern that will be brought up in future discussions with the board, with the staff, with the DCA as a whole. So with that, I'll have Ms. Whitney call the roll, please, for the vote.
Thank you. Kasuga,
Aye.
Cervantes,
No.
Rogers.
Aye.
Thank you. Motion passes.
Thank you so much. We'll move on to 5B2, AB 677. Ms. Mancia?
Thank you, Dr. Kasuga. AB 677, Professions and Vocations. This proposed bill was introduced on February 14th, 2025 by Assemblymember Jose Luis Solachin. This bill requires that the Department of Public Health and the boards under the Department of Consumer Affairs allow applicants who are unable to speak, read, or write English to use an interpreter at no cost to the applicant for the verbal and oral portions of the licensing or certification exam as applicable, provided that the applicant fulfills all other licensure requirements. The interpreter must meet specific criteria, including that holding a license for which the applicant is applying for. Additionally, the bill requires the boards and DPH to display on their websites that applicants who cannot read, speak, or write English may use an interpreter. Furthermore, the bill mandates that licensure or certification applications include a section where applicants can indicate their preferred language. Additionally, beginning July 1st, 2027, DPH and boards will be required to review applicants' language preferences, and the boards will need to report the language preferences data annually to designated legislative committees. On March 3rd, 2025, AB 667 was referred to the Committees on Business and Professions and Health. On April 1st, 2025, the bill was amended to remove the language of at no cost to the applicant. So these changes also included provisions that an interpreter shall not assist the applicant with the examination, and the board shall not charge an applicant fee, penalty, or surcharge for the applicant's use of an interpreter. On April 2nd, AB 667 was re-referred to the Committee on Business and Professions. At that time, the board had determined to recommend a position of support with clarification that with clarification for an amendment that there be clarification that the cost of the TOEFL and establishing limited English proficiency was at the cost to the applicant. However, on April 9th, 2025, the bill was again amended, specifying that the bill is to be enacted under the jurisdiction of the Department of Consumer Affairs as specified in Section 101, with the exception of the boards within Division 2, commencing within Section 500, which is applicable to the board. With the current amendments as written, the board is exempt from permitting LEP applicants who cannot read, speak, or write English to use an interpreter to interpret the English written oral portions of the license examination. As this bill was originally a bill recommended for review, we can move it to a watch bill list and continue to monitor for any additional amendments.
Thank you, Ms. Mancia. Any board questions, comments, motions? Yes, Dr. Cervantes?
I have a question, and I couldn't visualize the impact on our licensees of this bill. Could you help me with that as a practitioner?
I can speak a little bit about that. So I guess the intention of the bill is to provide someone who's taking one of our either one of our tests, the CP, the EPPP, and CAPLE, is that what it's called now? I mean, it's called different when I was taking the exam, to be provided an interpreter to take the exam, and that our board will pay for the cost of that. And as far as I will have like the board staff talk more about how many of our licensees would this be roughly, like an estimate of how many of our potential licensees or applicants would require this? I think would be helpful for Dr. Cervantes to kind of like understand, and also what costs. And I believe that part of it will not just be the interpreter or translator for the person taking the exam, but also there are fees with regards maybe a room if they're going to need an interpreter to read to them the exam in whatever language is preferred by the applicant. So there's fees that the bill wants to have us cover. But I will have board staff talk about what the impact would be for the board.
Hi, Dr. Cervantes. Yes, so as originally written, there would have been some costs. So for example, as Dr. Kasuga mentioned, there would have been room costs because interpreters would have required for applicants to have a separate room. Additionally, when it was written as at no cost to the applicant, the board would have been responsible for pay for the interpreter costs for the applicant. So that would have applied to both exams, as there are 2 exams that applicants take. And those fees would range depending on the language that the applicant would need the interpretation for.
Give me 1 second. Let me just clarify. The reason I couldn't imagine it for our licensees is because don't we already have in our regs a TOEFL, like a requirement to have a TOEFL to submit if they have earned their degrees abroad to submit translation? I mean, I appreciate the intent. I guess I was just trying to figure out, like, does it actually impact our licensees and our applicants, our applicants at that point?
So my understanding is the TOEFL is taken by the applicant to show their limited English proficiency. And so if an applicant can demonstrate that they have limited English proficiency, they could still take the test, but then now they will be, as if it's like how the legislation was intended, now they will be provided a translator for whatever language they're proficient in. So they can take the test in their preferred language. So it's going to be read to them because they're not able to understand it in English in such a proficiency as demonstrated by their TOEFL score.
I see it now. Thank you.
And I'll let Ms. Mancia expand on that and continue with regards what she was earlier talking about.
Yes, and in terms of our regulations, because we do require the TOEFL, it would have impacted us in a way that we would have also had to go back and change our regulations if it was not clarified. That's why we had originally specified that clarification needed about the TOEFL, that when they mean by at no cost to the applicant, would that also include the TOEFL? And if so, then we would have had to go through some regulatory changes to change our language about requiring the TOEFL, because now it would not be at our expense. It would now no longer be at the expense of the student having to establish having to pay to establish LEP status, but it would be at the board's cost. And we would then have to go back to PSI and ASP, with both the agencies who we have contracts with, to then redo those contracts to determine the cost of the shared cost. So there would have been a lot of administrative impact.
Okay, but now because the cost is this clarification and the cost being passed to the applicant, the impact is less on us operationally and our pool of applicants for licensure.
Well, we've been exempt. So we, being part of the Healing Arts with the new bill language that was just amended as of the 9th, we are one of the boards that falls under Division 2. The bill may change again. I mean, it went on the 1st, it was amended, and then on the 9th, it was amended. So it could be amended again in a few days. But as of the 9th, those boards under Division 2 are exempt from having to exempt from the bill.
Yeah. So this doesn't apply to us, but we'll keep your recommendation, the board staff recommendation is to watch it in case we're added or anything that affects our board.
The memo says support. Are you looking at something different?
I guess
Ms. Mencia did say that
it's a
we
new
could move it to a watch bill, that was a possibility.
Okay, I did hear her say that, and I was questioning because it was different than the.
I think it was a recent development from April 9th. Is it April 9th or?
Yes. Sorry, this is John Burke, the Executive Officer. The bill was amended on 4/9. That often means we don't actually see it until the day that we get to see it one day later. So obviously the board materials are for a different version of the bill where we said, oh, we should support because it will potentially increase access to linguistically diverse populations. So we think even though there will be a cost to us, it's something we believe the board would probably welcome. Now all Healing Arts boards under DCA have been exempt. But again, like Ms. Mencia already mentioned, the bill will likely be amended again. So it's important to watch it, even if now supporting it doesn't make too much sense, the current iteration of the bill. But who knows, the situation may be very different in May. Thank you.
All right, any other board comments, questions? Motions? Well, I move to recommend to the board to watch AB 667. Can I get a second?
I second that.
Chair, you're certainly welcome to have a vote on this if you want, but I think because it's currently in a watch form.
Oh, we can just like transfer it into watch? Okay, sounds good.
If it's currently watch and we are maintaining a watch, then there's effectively no change.
Sounds good. Yeah. All right. So I'll just like okay, so we're at 11:08. I will ask for a public comment for this one, and then I'm thinking of going into like a 5-minute break. So Mr. Moderator, can you open the public comment section?
Absolutely. We are open for public comment on agenda item 5B2. This is Assembly Bill 677. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand. And as a reminder to our mobile device users, you may need to hit the ellipses button. That's the ... in order to find your hand. We're going to take a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue?
Yes, please. Thank you. So for now, let's have like a 5-minute break and resume at 11:15. Is that enough time for the committee? Okay. So we'll resume at 11:15. Do we need a roll call?
I believe so.
Okay.
Okay, I don't see Dr. Rogers on camera, but I'll call roll. Kasuga,
Here?
Cervantes,
Here.
Rogers.
Here.
Thank you. Quorum established.
All right, we'll move on to agenda item 5, B3, SB 641. Ms. Mencia?
Thank you, Dr. Kasuga. Department of Consumer Affairs and Department of Real Estate, States of Emergency, Waivers and Exemptions. So this bill was introduced on February 20, 2025 by Senator Angelique Ashby. This bill expands upon Governor Newsom's executive order N1525, which was issued on January 29, 2025 in response to Southern California's state of emergency. The executive order N1525 postpones for 1 year the license renewal fees for the Department of Consumer Affairs licenses that expire between January 1st, 2025 and January 30th, 2025. And for those whose residential or businesses address is within the impacted areas. This bill grants the Department of Real Estate and the boards under DCA the authority to waive licensing fees, duplicate fees, examination fees, and continuing education requirements for applicants and licenses affected by declared federal, state, or local emergency and whose home or businesses were in the disaster area. So this authority actually has no repeal date. The bill would also require all applicants and licensees to provide an email address to their respective boards or departments. This bill also prohibits contractors and contractors that are licensed under the contractor state license law from engaging in private debris removal unless they meet certain qualifications or are authorized by the registrar during their declared emergency. Additionally, it would require the real estate commissioner to identify unlawful fraudulent practices during the state of emergency and provide public notice. The commissioner could suspend or revoke a license of any real estate licensee who makes unsolicited offers to purchase property in the disaster area for less than its fair market value. On March 5th, 2025, SB 641 was referred to the Committee of Business and Professions and Economic Development and the Committee on Public Safety. On March 18th, SB 641 was set for hearing for April 7th. On April 9th, 2025, SB 641 was amended. However, the amendments were minor. For example, the word private was removed. Board staff recommends that the board take a support position for SB 641.
Thank you, Ms. Mencia. Any comments from committee members? Questions? I do have a question, Ms. Mencia. How do licensees show proof about that they are within the impacted areas to qualify for the waiver?
So this is Cindy. They do have specific zip codes listed in the executive order for this particular one with the fires. Otherwise, we aren't requesting proof. We are just commenting, or we're putting it on our records that they've asked for a waiver, and we're looking at them individually.
Got it. So then it will be reviewed by the by board staff, or would it go through like the licensing committee, or what would that process be like?
Currently, they're reviewed by board staff in conjunction with the executive officer.
Got it. Thank you. Dr. Cervantes?
Do we, thank you. Do we know approximately what the fiscal impact might be on our particular board?
Right now, we have had, I want to say about 12 approved waivers. Not all of them are monetary waivers. Some of them have to do with CPD hours, like their records have been lost in the fire, or a class was canceled due to the fire. With the executive order, we are having payments, licensees can defer payments for up to a year. So they may not have to pay their 2025. However, we are letting them know they would have to pay 2 years in a row. So they would have to pay the full renewal fee in 26 and again in 27. So we do give them the option of if they want to keep the deferral that's on file right now, that's been automatically set up, or if they'd like to pay, we're removing that deferral and letting them pay now. So we are communicating with them what their options are and that it is not a waiver of fees, it's just a deferral of a year.
And this is Executive Officer John Burke. Even with the the extent of the damage and the number of people that live in the zip codes that are affected by the Los Angeles wildfire, the fiscal impact really has not been tremendously significant. Not as Ms. Whitney already mentioned, not everyone is availing themselves of the deferral, and I don't have the number. It's approximately about 15 or so people have availed themselves of it. So it's not it's not overly burdensome at this stage. Now there could be a disaster in the future, maybe where the whole state is affected again, and there could be a fiscal impact. But again, if it's a it's a fee deferral, so we don't anticipate it being overly problematic. Thank you.
Thank you. I think it's just a personal privilege. I just think it's important to have these types of policies to support recovery efforts in these kinds of circumstances. Thank you.
I agree, and I think that sadly this is not going to be the fires is not going to be the last time. And it's good that we are trying to be accommodating across the state for our licensees, because even with I understand that the fiscal impact is negligible or minimal right now. The impact to these practitioners is tremendous, as well as to their clients. So anything to kind of like provide the continuation of services for our consumers would be helpful for the practice as a whole. All right. Do I hear a motion? Yes, Dr. Rogers?
Yes, I move that we take a support position on SB 641
To recommend to the board.
to recommend to the board. Thank you.
Thank you. Any second?
I second the motion.
Thank you. It's been moved by Dr. Rogers, and we got a second from Dr. Cervantes. Can we open it now for public comment?
We are open for public comment on agenda item 5, B as in Bravo, 3. This is Senate Bill 641. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request, do you wish to continue with the motion?
Yes, thank you so much. Ms. Whitney, can you call the vote?
Kasuga,
Aye.
Cervantes.
Aye.
Rogers.
Aye.
Thank you, motion passes.
All right, moving on. We'll move on to 5C1. This is for information purposes only. I'll have Ms. Mencia.
Thank you, Dr. Kasuga. So this bill was presented to the board at our February 27th meeting, and I could briefly provide an overview if the committee would like, or we could just move on to a quick update.
I think kind of like a background would be helpful. This is quite the bill.
Okay. So AB 49 would establish legal provisions that prohibit artificial intelligence, use of certain terms, letters, or phrases that falsely suggest or imply that the care being provided by AI is from a licensed or certified natural person in healthcare profession. And the bill would also expand upon existing laws that make it illegal for an unlicensed individual to use terms or communications implying that they are authorized to practice in the healthcare profession. The bill also holds entities deploying AI technology responsible if they use AI language. Violations would be subject to enforcement by the appropriate healthcare boards, with each instance of misuse considered a separate violation. The board determined to take a support position for AB 49 with recommendations to strengthen the language. The language that was particularly recommended was to include reports and assessments. On March 17th, 2025, AB 49 was referred to Assembly Committee on Business and Professions and the Assembly Committee on Privacy and Consumer Protection. Any questions?
Thank you. Ms. Mencia, any comments or questions from the committee members? I just wanted to acknowledge the board staff with their efforts to bring our amendments to the authors of the bill. I will have Ms. Mencia or Mr. Burke talk a little bit about that meeting when for the stakeholders of I think healthcare practitioner stakeholders for this bill that happened in recently.
Yes, I'm happy to speak to that, Dr. Kasuga. So, as you know, we took a support, if amended, it was sort of a support with amendment position that we presented, and in conversations with the Assembly Member Bonta's office, the language we've proposed is in their new draft language. It has not been formally amended yet, as far as I'm aware, but it's looking good. We in BRN had some Board of Registered Nursing had some recommended edits. I've seen a version again, a draft version, which includes our language, which is wonderful. It also includes BRN's language, which really doesn't impact what we want to do or what we like about the bill. But it's been very productive conversations with the author's office.
Thank you, Mr. Burke. As a psychologist that does assessments, I really appreciate the addition of reports and assessments to this language. And just to clarify, this is when an unlicensed person uses AI and pretends to be a healthcare professional or a psychologist providing diagnoses or providing an assessment. It's unlicensed and kind of like a little bit like fraudulent, kind of like misrepresentation of being a psychologist in not only in doing therapy, but also assessments and reports that are provided. Any comments, questions, Dr. Rogers?
Yes, thank you so much, Dr. Kasuga. I had a question as I was reading through the information. So, in the board packet where it gives the summary of this bill, I was looking at this particular passage here where it talks about how there could be some companies that employ AI to take on the persona of a licensed healthcare practitioner. And so I'm just wondering if a complaint is brought to the board, what would enforcement look like in those instances? If it's not necessarily a specific individual, but companies that use AI to sort of impersonate a healthcare professional. Didn't know if we've been talking about that, but I was just curious how that might, what that might look like.
Hi, Dr. Rogers. Can you hear me? This is Sandra.
Yes, thank you.
Absolutely. So this is obviously something new for enforcement, but we do have the Division of Investigation, which is where they can go out and interview witnesses, collect evidence for us, and help us determine whether or not there's been a departure. And that is something we would do. In fact, I spoke to DFI earlier this week about AI cases. And as of right now, we've received about 3. And we're going to actually need to have experts that specialize in AI as well to help us determine whether or not there's been a departure. But for the most part, we're going to handle these type of cases the way that we handle all of our cases. We're going to rely heavily on the Division of Investigation, as well as, again, our experts that specialize in AI, and also with the Attorney General's office. If there is a departure that's been determined, we will work with the AG's office to impose discipline as well. But it is new for us. It's new to DFI, but we will do our due diligence in investigating and trying to determine if there is a departure, but we'll handle it like we handle most of our cases.
Okay, that's really helpful to know. I know that we are in a new landscape, and so we'll have to meet the new times with new measures while still maintaining our focus on consumer protection. So thank you so much, Ms. Monterrubio. That's helpful.
Absolutely.
And what I appreciate about this broader audience that we have right now of licensees out there practicing in the field, knowing about our bills that are in existence or soon to be in existence, can help us really regulate the practice by lodging complaints if you think that there is a departure, or if you think that there is not, if you have knowledge of AI being used, because we're only able to investigate complaints that are forwarded to the board. So we would need the participation of everyone who can let us know what is happening out there in across the state in different different types of psychology practices, whether it's in therapy or assessments. So I think that this bigger audience is definitely going to be helpful in what we do in protecting our consumers. Any other comments?
Hi, Dr. Kasuga. This is Sandra again. I wanted to thank you for that comment that you just made. In order for enforcement to do their due diligence, we do need individuals to file complaints. Even if you're not quite sure if there is a deviation, allow us the opportunity to investigate these complaints and make that determination. So thank you for your comment.
Thank you. With that, I'll open it up to public comments.
All right, we are open for public comment on 5C1. If you'd like to make a comment on AB 489, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand, and we will call on people in the order we have requests. And it looks like our first request comes from Elizabeth Winkleman. Hold on just a moment. We're sending you a request.
So I just wanted to remind again, our commenters not to bring pending complaints or possible complaints on the comment as a comment or as a public comment if it's something that might be forwarded to enforcement. Just a reminder. Anyway, go ahead, Dr. Winkleman.
Thank you, Dr. Kasuga. This is Dr. Elizabeth Winkleman with the California Psychological Association. I wanted to thank you for your support of this bill. CPA is also supporting the bill, and I believe actually that your amendments were incorporated into the bill language just yesterday. Our government affairs director has been monitoring this. And I just wanted to highlight that we have really heard and read in articles about some of the really terrible consequences that can come from the impersonation of mental health providers. I personally was shocked to hear if you go to this thing called Character AI, which is very popular, that there's been over 180 million conversations with a character called psychologist. So there's like a tiny, disclaimer. I guess this is going to be changing, hopefully, but and there's a couple of lawsuits from young people, families who have gotten into really significant problems, including one who committed suicide after interacting with an AI character, and another who became violent. And anyway, so just wanted to thank you for your support and kind of amplify how dangerous that this can be for these AIs to, there's possible positive utilization of AI in the healthcare and mental health field, but certainly impersonating and giving the impression of being a licensed mental health care provider when it's a bot certainly is a dangerous activity and shouldn't be done. So thank you for your support.
Thank you, Dr. Winkleman.
All right, next we're going to hear from Marilyn Imuz. Hold on just a moment, please. We're sending you a request to unmute your microphone.
Can you hear me?
Yes, go ahead, please.
Yes, this is Dr. Imuz, again from the California Department of Corrections and Rehabilitation. I just wanted to, FYI, CDCR is also dealing with this issue and developing policy procedure around this. I've been part of those discussions. You know how old I am. I'm 76. And I've had a hard time understanding it, but I've had staff who are very diligent and walking me through things, so I am getting a better picture of it. Obviously, we have our charting issues, and we have also assessment issues that could be influenced. One piece, it's a little bit easier to understand in relationship to our health record, which is where most things go. But how would a person in another setting discover if something was produced by AI? Can somebody elucidate on that for me? Does anybody have an answer to that? You obviously have to have proof if someone were bringing a complaint to the board. How would they even know that something is produced by AI and not a person?
Thank you, Dr. Imuz.
You're welcome. Can you hear me? Oops. Did I do something wrong on the computer?
No, no, you're still with us.
Oh, okay. So I said, it's not my strong point, anything to do with the computer, so.
All right.
Hi,
Thank
Dr. Kasuga, would you like me to try to respond to this answer?
Please. Yes,
Or
yes.
this question? I'm not quite sure how the consumer would know. I mean, I'm somewhat familiar with Chat GPT. I don't know if consumers are aware of that either. Because it's so new to the board, I really
Yeah.
can't answer exactly how a consumer would know. But again, we
Mhm.
encourage those individuals, if they have a suspicion that it is AI driven, to please contact the board. And again,
Okay.
with our investigators and staff and subject experts who could specialize in AI, they would help us determine whether or not it was AI driven.
Okay, all right. I appreciate
that
that.
helps.
I actually do know something about Chat GPT, by the way, because
Yes.
somebody had to explain it to me, like they were explaining it to an orangutan, so.
Oh, no, I'm somewhat familiar with it.
Yeah.
And there's so many different platforms out there. But again,
Yes.
if a consumer feels that, they have a suspicion that it's AI driven, please contact the board, and let us investigate.
Okay, so that's where we start, if there's a suspicion. And then
Correct.
there's an investigation. Thank you for that.
You're welcome.
Thank you, Dr. Emus.
All right, next we're going to hear from Doug Court. Hold on just a moment, please. We're sending you a request to unmute your microphone. Are you with us, Doug?
Yes, can you hear me?
Yes, go ahead, please.
Hi, this is Dr. Doug Court, and it occurred to me that something that maybe hasn't been discussed yet is the fact that perhaps we're seeing a patient who is also seeing somebody in AI. And if that were the case and something went wrong, I wonder whether we want to consider the liability issues there.
That is an interesting scenario. I would have to kind of like ask Ms. Monterrubio again to make a comment, but I also think that with the AI thing, there's just like a lot of things that we're still that are new and that we're gonna continue to navigate what action can be done. But I'll have Ms. Monterrubio comment if she has one.
Thank you.
Yeah, I think what you just said is right on, Dr. Kasuga. This again is very new for the board, so I can't really say, but it's something we would look into when we're investigating a complaint. But I think liability could be an issue down the road. We'll just have to figure this out as complaints are submitted to us and we investigate.
I would think too that if we have knowledge, it would be kind of like similar to if there is another practitioner that is practicing unethically. So if we have knowledge that our patient is potentially seeing an AI, we can either file a complaint with the board about the person or the company that is providing the AI-driven therapy or impersonation as a psychologist.
Yes,
Absolutely.
and I also think we need to have some guidelines in terms of what psychologists or practitioners need to tell their patients in terms of the risks of this, and maybe even considering if it's even, asking them to make a decision between working with this artificial intelligence group or you. In other words, not it's a version of dual relationships, perhaps. I think. I'm not sure.
Thank you. And with that, I will always ask our CPA people to help with guidelines and additional support for practitioners.
Great. Yeah. Good idea.
All right, next we're going to hear from Dr. Courtney Knapp. Hold on just a moment, please. We're sending you a request to unmute your microphone.
I just have kind of a selfish question. I'm a psychologist in private practice, and the billing software I use just recently started offering AI to help formulate notes for sessions. So I'm just wondering if that falls under this as well, or not. It requires me to do certain things in the note and then type a summary, and then they'll formulate my words. So I don't know, I guess sounds a little bit better than mine would. But anyways, I'm just wondering if this is something that would fall under the bill here. Thank you so much.
In my understanding, it isn't. It's only when someone is impersonating a psychologist in providing therapy, assessment, or report that isn't a psychologist. Right now, I know that like some psychologists sometimes use like a scoring software and that, kind of like uses reports. And we still have to read that. We still have to kind of like edit that, or like if you use like a grammar AI software to kind of like check your report. But then at the end of the day, the psychologist is still responsible for editing, doing the final edits, making sure that
the information is accurate.
yeah. So
Yep.
so like that's like separate, but I'm sure that eventually, there's gonna be some, but for now, this is separately just on AI impersonating a healthcare professional in either therapy or assessments.
Okay, thank you very much.
Thank you.
All right, I have seen a few hands flicker up and down. If you would like to make a comment, now is the time to get those hands up. We're going to wait just a few more seconds before we continue.
I definitely appreciate the lively discussion on this this bill.
Seeing no additional requests, do you wish to continue?
Yes, thank you, Mr. Moderator. All right, moving on. We're going.
I have a comment before we move.
Yeah, definitely.
This is a suggestion, not a compelling us, but some interesting topics emerged on the matter of AI and how it's coming into the practice. I don't know if we have capacity or enough to work with, but I wonder if we might start thinking about an ad hoc committee to explore these different ways that AI is coming into the practice. We just heard a comment on billing and support or develop our policies to support the enforcement function with the suggestion. It's not compelling.
No, definitely.
I'm just a lot of stuff started swirling here.
No, actually, that brings us into one of our watch bills, D7. And what I can do is I can have Ms. Mencia jump around on the watch bill and talk about D7 first. And for the watch bills, these are all just watch bills unless, something becomes, we might want to put a support or position on. So we'll
I'm mindful of the time, but traditionally we do at our first meeting when for our first hearing a bill, we will have we will have it introduced and then have discussion. And sometimes we will take positions on the bills that are suggested for watch. or that's been our practice. So I just want to be fair to the practice in case anyone does want to have a more rigorous discussion.
I mean, the committee is to recommend to the full board. It's not like we're not like speaking for the board. It's much more like we bring it to committee to kind of like look at this the watch bills, and from there we would like that's the reason why we have the watch bills like presented on committee, is to get like first look at some of the things that we would want to recommend to the board or continue to watch. But like in terms of time, I think we're doing okay. But I think that you provide us with a good segue to agenda item 5D7 of the watch bills. Ms. Mencia?
Thank you, Dr. Kasuga. So yes, closely related to AB 489 is SB 579, Mental Health and Artificial Intelligence Working Group. So the proposed bill was introduced on February 20, 2025 by Senator Stephen Padilla. This bill would require the Secretary of Government Operations, who is appointed by the governor subject to confirmation by the Senate, to appoint a mental health and artificial intelligence working group by July 1st, 2026, that would determine the role of artificial intelligence in mental health settings. This bill would require the working group to take input from various stakeholder groups, including mental health organizations and academic institutions. The bill would also require the working group to produce a report of its findings to the legislature by July 1st, 2028. On March 5th, 2025, SB 579 was referred to the Senate Committee on Governmental Organizations, and on March 7th, it was set for hearing for March 25th, and on March 25th, it was amended. However, the amendments were minor, such as removing of commas and things. March 26th, 2025, SB 579 was referred to the Appropriations Committee on April 4th. It was set for hearing for April 21st.
Thank you, Ms. Mencia. I have a question. Did they specify which stakeholders will be considered for the working group?
No, it said various groups, and then the specification was including health organizations and academic institutions. But it did not go further into details to who those health organizations are or who those academic institutions would be.
Thank you. So any discussion or questions for the committee? So I think that like, AI is definitely something that is coming into our lives. Oh, okay. Go ahead, like Dr. Cervantes. I'll give you the floor.
I guess just on my previous comment about an ad hoc committee for our board, I guess any number of things can happen if this legislation passes, right? And there may be gaps or things that are important to us and to our licensees that maybe are not captured, or maybe they'll have recommendations and we won't necessarily be ready to implement them. So I guess it just makes the consideration, Mr. Burke, if there might be capacity of kind of exploring these concepts with AI in the practice. Maybe just a little more pressing?
I think there would be, I mean, capacity, it would be, it's an ad hoc committee, presumably, so it would be 2 board members who could, you know, and those are always easier to schedule in terms of there's no public noticing, and just to begin discussing and researching and considering some areas where this is evolving. I think there would be capacity for that. For sure, it's whatever the board determines is necessary or desirable. We can go from there.
Yeah, I definitely think that sorry, there's an echo. Yeah, I definitely think that like there is, when it comes to the board work, definitely we're always behind. Like we kind of like sometimes have to wait until people are harmed, and that's always been very troubling for me before we act on enforcement or have the ability to protect. So we're always behind, and there are some people that get hurt or consumers that we are unable to protect before the board can take action. So I think that like an ad hoc committee might be something that maybe can be, you know, discussed in a future. I don't know if that's something that like our committee can recommend for our executive or our president, but I definitely hear your and share your ideas and concerns, Dr. Cervantes, and I would probably want to, you know, serve in you know, if there was ad hoc committee. But that's like I think something that is I'm not sure if that's like something that our committee would be involved more so than Dr. Tate and Mr. Burke. Is that correct? Or I don't know what our capacity is as a committee.
I don't think you could create the committee, sorry, could create an ad hoc committee, but you could recommend to the board president that an ad hoc committee be established to look at the impact on the practice of psychology and consumer protection on artificial intelligence. Something like that. That would be appropriate.
Okay, thank you. Dr. Rogers.
Yes, I just had a question, and forgive me, my memory escapes me, but did we explore something to this degree during our strategic planning meeting when we were talking about the changing landscape of the profession? I can't recall if we addressed this and if it's part of the strategic plan, and if so, if that could be a framework for how we move forward.
I believe it is. I'm not sure if it's under legislation or enforcement.
Okay.
If I recall, the discussion was about following technology and the evolution of the profession. So it was broad enough that that we could come into this space, at least how I'm understanding it and in recalling. I don't know. I'm wondering, just sorry, I kind of brought something up that maybe Mr. Burke, would it be helpful if we actually had a motion to make a recommendation to the board, or is that even necessary? Can they just have that discussion administratively?
Certainly, and I will defer to Anthony on whether it needs to have a formal motion, but based on the conversation that we've had and what I understand the will of the committee to be, it's a conversation I can have with Dr. Tate of the side, and it can be presented and discussed again at the May meeting. The item could be on the agenda for the May meeting. We could do that, again, at the president's discretion. I don't think there's really a wrong way to proceed. Yeah.
I think John's right. I think we could exactly go that approach.
And if I may, just for consideration, Sean, an interest of mine is providing adequate support to our enforcement unit to, so that there's some clarity in our exploration of this topic, so that there's some clarity for them in their part of the practice when they're enforcing regs. I just thought that might, if you need to bind it some way, I thought that, like, as an end goal. Am I making sense?
Yeah.
Yes. Yes,
All
you
right.
are, Dr. Cervantes.
Okay.
Okay, so let's go back to agenda item number 5 on this the SB sorry, I got lost, 579. So like in the broader discussion of mental health and protecting the public, I feel like it's to the board's interest to support legislation that provides us with more information on mental health and AI. So I am inclined to, support any other avenues where more information about mental health and AI is being done. Because there's, this one it's kind of like all hands on deck because the technology is moving so fast and there's only so much that we can do to protect people. So do I hear a motion about this bill, or do people feel like a support watch to watch this bill?
Personally, I'm comfortable with a watch position. I don't know if the board members who are practitioners might feel more strongly about advocating for a psychologist, a practicing psychologist, to be part of this work group, or I don't know if that may be like if they, meaning you guys, feel strongly about that, that might be an opportunity to weigh, to to offer support or somehow advocate for that.
Thank you, Dr. Cervantes. Any thoughts, Dr. Rogers?
Hi, thank you so much, Dr. Kasuga. I am fine with continuing this as a watch bill.
All right. Okay, thank you so much. So with that, we'll move on to the rest of the watch bills, starting with D1, Ms. Mancia.
Okay, thank you, Dr. Kasuga. So the first 3 watch bills actually listed have already been presented to the board, and I could briefly go through each of them. I just want to be mindful of our time. So would you like me to go through the first 3 briefly?
Yes.
Okay. So AB 81, Veterans Mental Health. So this bill was introduced December 19, 2024 by Assemblymember Trita. This bill would require the Department of Veterans Affairs to establish a fund for the academic study into mental health of women veterans in California. The study would include demographics, stressors, risk factors, treatment modalities, barriers to treatment and suicide rates, and any other relevant information pertinent to studying mental health. No specific funding amount was specified or recommended, but the bill does specify that a report with the findings and recommendations would need to be submitted to the legislature no later than June 30th, 2029. As of February 27, 2025, AB 81 was presented to the board for possible position, and it was the board determined to have it as a watch bill. Any questions? If not, I'll move on to AB 257.
No questions for me?
Okay. AB 257, Specialty Care Network, Telehealth and Other Virtual Services. The bill was introduced on January 16th, 2025 by Assemblymember Heath Flora. This bill would require the California Health and Human Services Agency, in collaboration with the Department of Healthcare Access and Information and State Department of Healthcare Services, to establish a demonstration project for telehealth and other virtual services and specialty care network. The demonstration project would be known as the Equal Access to Specialty Care Everywhere. The Equal Access to Specialty Care Everywhere network would serve patients of safety net providers consisting of qualified providers, rural health clinics, federally qualified health centers, and community health centers. The purpose of the demonstration project is to increase access to behavioral and mental health services and additional specialties prioritized by the agency. The bill will also require the project to include a grant program to award funding for administrative costs resulting from the demonstration project. To receive funding, grantees must meet specific conditions such as establishing through contracting direct hire or partnering a network of clinical specialists, providing health information technology and technical assistance to support both the specialist and the primary care provider. The purpose of the grant program would be to achieve certain objectives, including reducing structural barriers to access experienced patients and improving cost effectiveness. On February 10th, 2025, AB 257 was referred to the Assembly Committee on Health, and on February 27th, AB 257 was presented to the board for possible position recommendation. The board determined to keep it as a watch bill. On March 26th, AB 257 was amended to clarify how grant funds would be granted and how funds are to be spent and how the grant would be regulated. The new bill language also specified an agency would be required to administer the grant program and arrange independent evaluation of the demonstration project. On March 28th, AB 257 was referred to the Appropriations Committee, and as of April 9th, AB 257 was set for hearing, though no date was listed. If no questions, I'll move on to AB 277.
Go ahead.
Okay, so AB 277, Behavioral Health Centers, Facilities and Programs, Background Checks. The proposed bill was introduced on January 21st, 2025 by Assemblymember Juan Alanis. The original bill required the California Department of Developmental Services to establish a certification process for behavioral technicians, including a criminal background check for those working with minors. The bill would prohibit the department from certifying an individual who has been convicted of a crime involving a minor. The bill will also prohibit a developmental center, facility, or program that provides services to a person who is under 18 years of age from employing a behavioral technician who is not certified by the department. On February 10th, 2025, AB 277 was referred to the Assembly Committee on Human Services. On February 20th, AB 277 was amended to include all persons who provide behavioral health treatment for behavioral health center, facility, or program to undergo background check and exclude persons convicted of a crime involving a minor. It is now retitled Behavioral Health Centers, Facilities, and Programs Background Checks. On February 21st, 2025, AB 277 was re-referred to the Assembly Committee on Human Services, and on the February 27th, AB 277 was presented to the board for possible position, and the board determined to keep it as a watch bill. Any no questions, I will move on to AB 346.
Thank you.
AB 346, In-Home Support Services, Licensed Healthcare Professionals. This proposed bill was introduced on January 29, 2025 by Assemblymember Stephanie Nguyen. This bill proposes to broaden the definition of licensed healthcare professionals to include any individual engaged in activities requiring licensure or regulation under specified provisions of the BPC, under the County Administered In-Home Support Services program, which provides services to qualified aged, blind, or disabled individuals to help them remain in their homes and avoid institutionalization, A licensed healthcare professional is defined as someone licensed in California within the scope of their professional license. This bill reinforces the requirement for applicants or recipients of the IHSS program to obtain certification from a licensed healthcare professional to receive paramedical services. On February 18, 2025, AB 346 was referred to Assembly Committee on Human Services. And we did, no questions, and I can move on.
Go ahead, thank you.
So we did move around a couple of bills. We're actually going to talk, I'm going to present on SB 518 before I present on AB 742. So SB 518, Descendants of Enslaved Persons Reparations. The proposed bill was introduced on February 19th, 2025 by Senator Akilah Weber Pearson. The bill would establish the Bureau for Descendants of American Slavery within state government. The governor would appoint the director and confirmed by the Senate to oversee the Bureau. The bill would require the Bureau, as part of its duties, to determine how an individual's status as a descendant would be confirmed. The bill would also require proof of an individual's descendant status to be a qualifying criterion for benefits authorized by the state for descendants. Former law, until July 1st, 2023, established a task force to study and develop reparation proposals for African Americans, with special consideration for African Americans who are descendants of persons enslaved in the United States. On February 26, 2025, SB 518 was referred to Senate Committee on Governmental Organization and Senate Committee on Judiciary. AB 518 was originally set for hearing March 25th, but was canceled upon author's request and has been set for hearing on April 22nd. On April 7th, 2025, SB 518 was amended to specify the Bureau of Descendants of American Slavery would be established within the Department of Justice and under the control of the director, who would be appointed by the Attorney General, not the governor. Okay. No questions. I will move on to AB 742. So AB 742, licensing applicants who are descendants of slaves. The proposed bill was introduced on February 18, 2025 by Assembly Member Shadeh El-Hawari. This bill would require boards and bureaus by license and bureaus that license and regulate various professions to prioritize applicants seeking licenses who are descended from a person enslaved within the United States. The bill would make these provisions operative only if SB 518, Descendants of Enslaved Persons and Reparations, is enacted, establishing the Bureau of Descendants of American Slavery. This bill would repeal those provisions 4 years from the date on which the provisions become operative, or on January 1st, 2032, whichever is earlier. On March 3rd, 2025, AB 742 was referred to Assembly Committee on Business and Professions. On March 13, AB 742 was amended to clarify descendants of slaves to descendants of American slaves. On March 17, AB 742 was referred to the Assembly Committee on re-referred to the Assembly on Business and Professions. And any questions on that? Since we did review SB 579, I can go straight into AB 479. AB 479, Criminal Procedure Vacature Relief. The proposed bill was introduced February 10th, 2025 by Assembly Member David Tankipan. This bill would require the court, before it being vacated the conviction, to make findings regarding the impact on the public health, safety, and welfare if the petitioner holds a license as defined and the offense is substantially related to the qualifications, functions, or duties of a licensee. The petitioner or licensee must provide the board 45 days to respond to the licensee's vacature request before the court can make its findings. On February 24, 2025, AB 479 was referred to Assembly Committee on Public Safety. On March 26, 2025, AB 479 was set for first hearing, but was canceled at the request of author. Any questions? And last, AB 985, Healthcare Practitioners, Titles, and Name Tags. The proposed bill was introduced on February 20, 2025 by Assemblymember Patrick Aarons. The bill proposed an amendment to existing law under the Medical Practice Act, which regulates the licensure and practice of physicians and surgeons in California. It would specifically make it unlawful for anyone to use the title doctor or the letters doctor in their name tag unless they are authorized to do so under the law, such as being a licensed physician. On March 10th, 2025, AB 985 was referred to Assembly Committee on Business and Professions. On March 24, 2025, AB 985 was amended to specifically make it unlawful for any person to call themselves an anesthesiologist assistant unless they meet specified requirements for licensure. On March 25, 2025, AB 985 was re-referred to the Committee on Business and Professions. The language pertaining to name tags and use of title of doctor were removed. This bill was retitled to anesthesiologist assistants. Staff will continue to track the bill in the event that this bill is amended further.
All right. Thank you, Ms. Mencia. Any board comments for the entire watch bill section? Seeing, okay, Dr. Cervantes.
Just have I have a general question. We spent a lot of time last year on a similar bill regarding the title doctor, and we had a lot of discussion. It triggers a lot of feelings for individuals who have earned doctoral degrees.
Mm-hmm.
I just have a general question. Is there something happening in the health profession that people are using the doctor title and it's like causing this, or like there's just it feels like we're having a lot more activity in this area. Ms. Mencia, is there a broader issue that is hitting the legislature that this bill is trying to address? This AB 985, it is very similar to another bill we spent a lot of time during the last legislative session.
Hi, Dr. Cervantes, thank you. I have a response, but I'm not sure if it's going to directly answer what you're getting to. So the original bill, it was actually addressing a lot of the field of nursing. And so, and I believe it was like a registered nurse and then doctored nurse. And so the use of that and titles. And so, but because it overall addressed the area of the use of doctor, we were watching the bill and then we thought maybe we could recommend a position. So I don't necessarily believe that it's, I do believe that the bill and language does specify that academic institutions, for example, that it does not apply to anyone that holds a doctor, for example, PhDs, that have earned EDDs, et cetera. So it's not so much that the medical field doesn't want those that have earned doctorates in other areas to not be able to call themselves doctors or to not use those titles, that within their profession, my understanding from when I was reading the language was that there's a little bit of something that might be going on with
yeah. Understood. I think you're right. I get it. Recently the state legislature, like in the last 6 or 7 years, authorized the California State University to offer doctorates in nursing because there's a workforce shortage on people who can teach faculty in nursing programs, right? That's clearly like, right, what your comment, there are more doctorates of practice just in the academy. There's just more of those. And so that's probably what's going on.
Yeah, in terms of like the Board of Psychology, I think that we always have to watch any bills that addresses the title doctor, just in case it affects our ability to use doctor for our profession. So it's always, even if this one is like, not related to ours, but it's always good to watch anything because we don't want anything to stop psychologists from being able to, use the title doctor. Just to move things along, Mr. Moderator, can you open the public comment, please?
We are open for public comment on all of agenda item 5D, the watch bills. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand. And as a reminder to our mobile device users, you may need to hit the ellipses button, that's the ... in order to find your hand and maybe unmute. All right, our first request is coming from Tyler Rind. Hold on just a moment, please. We're sending you a request to unmute your microphone.
Good afternoon. Tyler Rindy, Director of Government Affairs with the California Psychological Association. I want to speak on SB 579 by Senators Padilla, CPA, alongside with the California Association of Marriage and Family Therapists, were the co-sponsors on that bill. Really appreciated the conversation around AB 489 and the subsequent conversation on this bill. We would like to request you all to make a recommendation to the full board to support this bill. This bill was coming out of that AI is an emerging technology. It's impacting across, many the practice of psychology, the practice of other mental health professions. It's huge, and it can impact, ethics, note-taking, actual practice, enforcement. So that's why we brought it to Senator Padilla as an idea of let's establish a state work group on this to grapple and look at it from all different lenses with the goal of making a report to the legislature in 2028 and hopefully maybe an interim report before then to look at what are reasonable state regulations that can end up impacting the field and the field more broadly. So we're bringing it to you all as, hopeful that you would all take a support position on this bill. Just to respond directly to Dr. Cervantes about not seeing a psychologist represented on the actual working group. We had put language forward as that it would be licensed behavioral health professionals that are selected in consultation with mental health professional organizations with the hope that a psychologist would be on it. But we view that the work is broad enough and it's more important to have the work go and move forward rather than have a battle between whether it's an LMFT, a psychologist, or an LPCC. So that's why the language is a little bit broader and you don't see an actual psychologist directly represented on the work group, but we're hopeful that a psychologist would be on the work group. I will say that the author is considering right now a lot of amendments on who's the makeup of the work group. We've heard from labor, we've heard from a bunch of other groups that want to be on the work group. So if that's something that the board would like to see an amendment, I think that the author would be open to a discussion on that. So I'll stop there and just, again, request this committee to make a recommendation to the board for a support position. Thank you.
Thank you, Mr. Rindy, Dr. Rindy.
All right, next we're going to hear from Zania Mendoza. Hold on just a moment, please. We're sending you a request to unmute your microphone.
A psychologist, Zania Mendoza. I first wanted to just emphasize my agreement with the previous caller, Dr. Rindy, and also to Dr. Kasuga's and Dr. Cervantes' points earlier regarding creating a group for watching AI and its involvement in mental health. The only exception is that I strongly hope that the board takes a supportive position with the amendment to mandate or require a psychologist to be part of that group. I think that making it broad is important, but a lot of what AI has the potential to influence, I think really impacts the work that we do, in particular, such as assessment and diagnosis and report writing. Because that tends to be some of the bottlenecking in terms of access, I could see that being a big area of concern that maybe professionals with other credentials would not fully appreciate in the same way. So I think it's absolutely critical to include a psychologist on that group. My second comment was related to the name tags. To Dr. Cervantes' question, actually in healthcare, a lot of allied health professionals and other traditionally master's level clinicians have moved towards doctoral level requirements or education degrees being offered, even if they're not required for their licensure. And I believe this is driving a lot of the concern from physicians, rightfully so, because there might be confusion to the consumer or the patients about who the doctor really is on their team. I do think that this does pertain to us. As I mentioned, I primarily have only worked exclusively in hospital settings with medically compromised individuals and physical medicine and rehab, much less so the mental health field. And I've always had the privilege of using my doctor title because it is written in the most hospital bylaws, and I believe California state law that allows psychologists, including a few other non-physician licensed clinicians, to have the privilege of using that title even in a healthcare setting. So while the dispute is not about academic pursuits, it's about specifically in
30
healthcare settings
seconds.
to reduce confusion. I do think that we need to watch it closely because as psychologists, we have earned that and have been offered that privilege in the past, and we should retain it, even if other professionals do not get to retain it. Thank you.
Thank you, Dr. Mendoza.
And those are our only 2 requests for this topic.
All right. Any other comments from the committee before moving on? Yes.
Given our comments on SB, given the public comment on SB 579, I am willing to consider a motion to take a support position, to recommend to the board a support position on that bill at this time, or I'm also open to suggesting it at the next board meeting so that we can have a more robust discussion, including I'm reasonably satisfied on my point about representation for the profession of psychology on this board. But I think I give that the privilege to those who earned the license to weigh in on that discussion. Although I'm reasonably satisfied with the comments we heard.
I think that a support, if amended, is kind of like more what I'm thinking of. But I think that some of the public comments brought in important information that the psychology field has unique AI. We have unique ethics compared to other mental health professionals. And with that, I think that having a psychologist as part of the working group is essential in addressing some of the concerns I have with regards to our consumers.
Did you want to contribute to the discussion?
Yeah, I was just about to say that I concur with Dr. Kasuga. I think it would be really important to have a psychologist represented on this working group.
So do I hear a motion?
The motion, as I think this is where I am. A motion to take a support, to recommend to the board a support position on SB 579 if it is amended to include a licensed psychologist in the work.
I second.
I third, but that doesn't really make sense. But I will have Miss Whitney call the vote for the motion put forth by Dr. Cervantes and second by Dr. Rogers.
Kasuga,
Aye.
Cervantes,
Aye.
Rogers.
Aye.
Thank you.
Well, thank you.
So-
We'll make Mr. Rind defend the position.
With that, we hit the 12:30 mark, and it's a hard stop for us for lunch. We are required to have a minimum of 45 minutes. So I am wondering if the committee members are okay with a 45-minute lunch break, or do people need longer? 45 is good?
45 works.
Okay, so we'll resume at 1:15. Thank you, everyone. All right, it's 1:15, and let's resume our meeting for the Legislative and Regulatory Affairs Committee. Ms. Whitney, can you please call the roll?
Kasuga,
Here.
Cervantes,
Here.
Rogers.
Here.
Thank you, and Court.
All right, I hope everyone had a good meal. We're gonna move on to agenda item number 6. It's for legislative items for future meetings. The committee may discuss other items of legislation in sufficient detail to determine whether such items should be on a future committee or board meeting agenda, and or whether to hold a special meeting of the committee or board to discuss such items pursuant to Government Code Section 11125.4. As showing on the screen. So I guess I wanted to just like add the bill that was mentioned by one of the public comments earlier by Dr. Wallace on AB 82, if we can look into that. Any other legislative items? Seeing none, we can open it up to public comments.
We are open for public comment on agenda item 7. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. If you'd like to make a comment,
Can we just make that small amendment? I think, are we taking public comment for agenda item 6, or is it 7?
6.
6, okay.
My apologies, agenda item 6. Regardless, we are still taking comments. If you'd like to make a comment, raise your hand by tapping that hand button. We're going to take a few
items.
We're going to take a few seconds now to see if we have a request for public comment.
Thank you, Mr. Moderator.
Seeing no request, do you wish to continue with the agenda?
Yes, please. Thank you. Moving on to agenda item number 7, regulatory update, review and consideration of additional changes. I will turn it over to Ms. Mancia.
Thank you, Dr. Kasuga. So for item A, disciplinary guidelines and uniform standards related to substance abuse abusing licensees. So this package currently is in the production stage. staff is working with regulatory counsel to finalize edits. Once those edits are finalized, it will be ready for the director's review. Any questions? If not, I'll move on to item B. No? Okay,
Nope.
item B, pathways to licensure. This package is currently in the drafting phase. Package will help streamline the licensure process. It is a part of another regulatory package to implement AB 282. Once the regulatory language for AB 282 is approved, staff will start reviewing the impacted sections and work with regulatory counsel to complete the draft language, which will then be presented to the board for review and approval. Next is C, enforcement provisions. Thank you. This package is in the drafting phase. The package requires statutory changes which are included in the board's sunset. Once the statutory changes are approved, staff will start drafting the regulatory language. Item D, corporations. Similar to enforcement provisions, this package is in the drafting phase. The package requires statutory changes which are also included in the board sunset. Once the statutory changes are approved, the staff will start drafting the regulatory language. Next, item E. Implementation of AB 282. So as mentioned earlier with the pathways to licensure, this package is in the drafting phase. The package is currently being reviewed by regulatory legal counsel and budget. And item E, did I skip one? No, I didn't. Sorry, item F, research cycle analyst regulation. This package is in the drafting phase. On May 10th, 2024, the board approved the adoption of regulations for research cycle analysts. On the 16th of 2024, August 16th, the board approved revised language, and at the February 27th board meeting, staff along with regulatory counsel presented the option to move away from the dual package and focus on one complete package. The board agreed, and staff is working with regulatory counsel to review package 1 and package 2 revised language as a combined to be submitted as one package. And I do want to point out that item G was a hand carry, and so would be in hand carry materials in case you don't see it as a memo. Standards of practice for telehealth services. This package is in the production stage. At the February board meeting, the revised regulatory language was reviewed and approved by the board, and staff is working with regulatory counsel to complete the required regulatory package documents. Any questions on any items?
Yes, Dr. Cervantes?
Hi, I just wanted to comment that I really appreciate in item E the timeline provided in the description. I think it's helpful as a reminder and for members of the public who maybe didn't attend all of our discussions on these items to have this as a reminder. I think that particular section is well written, and we should probably do that more often. Thank you, folks. Whoever wrote that, thank you.
All right. I agree. That's really helpful to see the timeline there. Any other comments, questions? Seeing none, let's move on to public comments on agenda item number 7.
All right. We are open for public comment on agenda 7, and I mean it this time. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take a few seconds now to see if we have a request for public comment. Seeing no request, you wish to continue with the agenda?
Yes, please. Thank you, Mr. Moderator. Moving on, we're on our last agenda item number 8, recommendations for agenda items for future board meetings. Note that the committee may not discuss or take action on any matters raised during this public comment section, except to decide whether to place the matter on an agenda for a future meeting. Since it's always my suggestion to add a mindfulness for our board meeting, I would suggest to have one for our committee meeting.
Happy to oblige. Thank you, Dr. Kasuga.
Thank you. It goes without saying that will be led by Dr. Rogers. Any other recommendations for agenda items for future board meeting? I think Dr. Cervantes had some earlier.
No, but I guess if the idea of the ad hoc committee looking at artificial intelligence moves forward, perhaps that can be an information item at a board meeting.
Thank you. With that said, I think we're ready to adjourn. Do we need a motion for that, or? I think we need one, just one, right?
Chair Kasuga?
Oh, we have, actually, I forgot about the public comment. I'm so sorry. Let's provide like a public comment for agenda item number 8. I am so sorry.
All right, we're open for public comment on agenda item 8. If you have a recommendation for a future board meeting or committee meeting item, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take a few seconds now to see if we have a request for public comment. Seeing no request for comment. Oh, I spoke too soon. We're going to call on Doug Court. Hold on just a second. We're sending you a request to unmute your microphone. All right, Doug, I saw you on mute. Are you with us?
Yes, I am.
All right, go ahead, please.
Hi, thank you. I just wanted to put in a plea, if you will, to monitor the movements that are moving us away from being able to use telehealth. I know our right to do telehealth has been restored, but I'm not confident that that's going to last. And I wonder whether our organization or perhaps some committee could keep an eye on it and make sure that the powers that be know how really central it is to many of our practices and to our patients' lives.
Thank you. Dr. Court, just to clarify, and you're talking about access to telehealth.
Yes, being able actually reimbursement for telehealth through Medicare.
Thank you.
And that appears to be our only request for public comment for this item.
All right. So that concludes agenda item number 8 and as well as our meeting. And I believe to adjourn, we need one motion.
Now, you can, but it's not required. You can.
So I guess we're adjourned. I invite Mr.
Chair,
Court to talk about the
yeah, perfect.
the CPD.
Yep.
And Dr. Cervantes has a comment too. Oh, you're saying bye. Yes, Mr. Polk, please.
Yes, thank you. Thank you for attending the Legislative and Regulatory Affairs Committee meeting today. For attending the full duration of today's meeting, 6 hours under CPD category number 1, attendance at a Board of Psychology meeting can be credited. The 6 hours will also apply to law and ethics. For your records, please notate today's date as April 11th, 2025, the name of today's meeting, which is Legislative and Regulatory Affairs Committee meeting, and 6 hours for your records. Please maintain this record as certificate of attendance will not be provided. Again, for attendees who joined by phone and called the U.S. toll number, please send an email to bopce@dca.ca.gov. Again, that is bopce, as in Board of Psychology Continuing Education, at dca.ca.gov with your name, license number, and the phone number of the phone you called in from. Attendees who signed in using a computer or mobile device from the WebEx link, your attendance is automatically documented and no further information is necessary. Thank you.
All right. Thank you to board staff for all the help with regards to this meeting, as well as to all the committee members. Thank you so much for the lively discussion and our public. With that, have a good weekend. Bye.
Thank you. Bye-bye.